H-1B cap 2025 is turning into a legal maze, from shocking $100,000 fees to sudden approvals. So, what's really happening behind the scenes? Today, we're going to sort of decode with our guest who will join us very soon. But before that, very happy to have all of you folks join us here on Immigration Talk Show. I'm Napasa, your host for today's session, and we're going to have a good time. And before we head on with the discussion, I have this important disclaimer to keep in mind throughout this whole conversation and the session that we are going to have today. And the disclaimer is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And now, without further ado, please help me welcome our guest for today, and Attorney Chand Parvathaneni from Dallas, Texas, SPV law firm. Hi, Chand. Thank you for joining us today.
Hey, Nipasa, thank you so much, and good to be on the show. Probably we'll have some valuable discussion on what's going on the H-1B side and all these new rules that are coming up.
Absolutely. It's scary and shocking also with the government shutdown. But like you were saying earlier, USCIS is still in function. So, what do you have to say? Any note today before we start off with the topic also?
Sure. I mean, it's almost 10 days since this government shutdown has started, and we're already seeing some impact. We have, theoretically, what's happening is the government is shut down. So, pretty much anything that is, does not have the funds, they're all shut down. And in the immigration world, we deal with USCIS, we deal with Department of Homeland Security, and then we deal with Department of Labor. Luckily, USCIS is self-funded, which means that they have enough funds. So even during a government shutdown, USCIS functions are typically not impacted. And things like ICE again, because it is of national security, that is funded and that is not impacted. However, Department of Labor, it's pretty much almost shut down. So Department of Labor is shut down, and what that means is we cannot get any new LCS done. And if anybody has an H-1B, their status is about to expire, they have to file for an extension. Or somebody has a new job offer and the company wants to apply, or somebody is within their 60-day grace period, and within the 60-day grace period they have to file for an H-1B. What that means is now, because Department of Labor is down, we cannot take new LCAs, we cannot get the new LCAs certified. Even if it has been filed, if it has not been certified, in the middle of the shutdown, they will not certify the LCA. So H-1B filings are impacted mainly because of Department of Labor's shutdown. But if not, if it's a case where DOL is not involved, USCIS currently is not impacted. The USCIS interviews are on time, they're on schedule. All the RFEs, they're going out as required. Approvals are coming in, receipts are coming in. So overall, USCIS, there is no impact, but anybody that needs a new filing that involves Department of Labor, we have a huge problem. And another big problem is the perm filings, the Department of Labor filings for the green card. The website is down. The flag website, which is used for the perm labor filings, the website is down. And what that means is we cannot file for any new perms right now. None of the perms are getting certified. So in the last 10 days, pretty much that's where we are. The problem is the perms have a deadline. So anytime the company is filing for a perm, they have to do the advertising, they have to do the recruiting. And once they're done with all the process, they have to file the perm, the labor application within a particular timeline. And right now, unfortunately, until the government shutdown is over, DOL will not be in action again. The websites will not function. So right now it is wait and watch and see what the guidance is. In the past, USCIS has come out with a guidance and said, if at all there is a government shutdown, they would treat that as something, some kind of an extraordinary circumstance, and they would excuse delay. And that's been said in the past, during the prior shutdowns. This year, for this shutdown, at this point of time, we have not had any communication, any guidance from USCIS. But we just hope that because it is an extraordinary circumstance, any excuse, probably any failure to file on time is probably going to be excused.
Yes, that's right. And thank you so much, Chand, for joining us today. I'm looking forward for this discussion on today's topic. Friends out there is H-1B cap 2025 and what should you know before filing. So I know many of you have questions, and I can already see Ricky, Shyam, Thank you for joining us with your questions. Stay with us. We are going to take them up a little later in the show. And good news is, all of you can also join us on call. The number is what you can see on the screen above. Just dial this number and you can join us live on call and ask your questions directly to Attorney Chand Parvathaneni. And the number is 425-436-6335, and the access code is 988-888. And check us out. We are live right now, not just on YouTube, but also on LinkedIn, Facebook, and on X. And you can also check us out on Instagram as well. So join us, stay connected with us. And now, Chand, I have my first question. I'll not delay much. So let's start with what everyone's asking online. Are people really still getting H-1B approvals after that $100,000 proclamation, or are those just isolated cases we are seeing on Reddit?
So, I mean, at this point of time, we do have data because after September 21st, once the proclamation is in effect, we did do a lot of filings. My colleagues at other law firms, they have done filings, and the cases are getting approved, and the rules are clear. I think if somebody is already on H-1B in US and somebody is filing for an extension of status or a transfer filing, the 100K fee should not be applicable, because the 100K fee is applicable when somebody is out of the country trying to enter USA. And in the last couple of days, we have seen approvals for cases filed after September 21st. We have also seen people go for stamping, and people have been issued visas. And these are people whose H-1B was applied before September 21st, and they're able to successfully get stamping without the 100K fee. So any filings that are currently being done in United States for employees in United States, either as a change of state, I mean, either as extension of status or some kind of a transfer. So any of these filings, the 100K fee should not be applicable, and USCIS is not asking for that fee at this point of time.
Thank goodness for that. I mean, I can't imagine. I mean, we have been chatting about fee hike. Before earlier, it was different, then it got higher, and now I think this is the highest ever. Especially that it is just a lottery. It's not like 100% visa, also, right, Chan?
Right. I mean, again, the 100K does not mean that they will get an approval. The 100K is just a fee. I mean, to be eligible for a H-1B. But again, this is for somebody that is out of the country, and typically it's going to show a lot of impact from the next March, April. In March, when you're going to have a new H-1B cap lottery, a lot of we're going to see this 100K impact during that time. Because right now, if anybody is already on H-1B, this and they're already in the United States, this proclamation should not impact them. But going forwards, because the new filings, the new H-1B filings under cap, they should be impacted with this 100K proclamation.
Right. And talking about it, if an employer files now and suddenly gets hit by this new $100K fee, can they legally back out halfway through and leave the applicant stranded?
So again, in general, the document that controls is the president's proclamation, not the interpretation by the agencies alone. That also makes a lot of difference. But the proclamation has a lot of language that decides how this 100K is going to be implemented. So this 100K is for basically for people who are out of the country trying to enter United States in general. But again, like you have asked, if USA suddenly comes back and says for a pending filing, you are required to pay this 100K fee. If the employers want to back out, the rule is at any point of time, employers can withdraw their petition. So they're going to lose the fees that they've paid so far. But in general, there is nothing that says they have to go ahead. So if an employer is in between the process and they get an RFE where they are asked for this 100K fee, employers can definitely back out and withdraw their H-1B.
Okay. Thank you, Chand, for taking that up. And my next question is, we are seeing posts about H-1B transfers being approved after September 21st. So is that a genuine pattern or just inconsistency from USCIS?
No, I think that is the right process, which is what is happening. Because for somebody who's in the United States filing for a transfer, that 100K fee should not be applicable. And we have done some filings. We are seeing approvals in our office. We are seeing, I mean, I talked to other attorneys. They are seeing approvals. And again, that is kind of expected because the proclamation is clear. I mean, it should not impact people who are in the United States. So somebody who is filing for a transfer uh, should not see this problem. And I think the whole reason why this confusion came up is because like initially, right after the proclamation, the White House press secretary, Caroline Leavitt, she came and she clearly confirmed it is only for cases from the next year's lottery. But then what happened was we saw some guidances coming from CBP came out with the guidance, USCIS came out with the guidance, Department of State came out with the guidance, and all of them talked about new petitions filed after September 21st. So people got confused. What exactly does this word "new" mean? And that is where a lot of there's a lot of confusion, a lot of people talking about it in social media, in forums, and all those things. And people got all these conflicting answers. But again, the proclamation, as we read it, it is very clear. It is for people outside the country, so it should not even impact anybody that is in the country. So again, it's a genuine pattern. So when people are here in the country filing for an extension or filing for a transfer after September 21st, that is theoretically not a new petition going under cap. And since they are in United States, that 100K fee should not be applicable. So I don't think it's an inconsistency. I think it's the right pattern. I mean, again, that is what the proclamation says, that those people should not be impacted, and that is what I see USCIS doing. So it's a pattern where USCIS is adjudicating cases without 100K fee if somebody already had an H-1B and they're just trying to extend status or file for a transfer.
Right, right. And this next thing I wanted to know is about OPT. If someone's on OPT now and planning to switch to H-1B next year, is it still worth staying in the US or is it smarter to look abroad?
I mean, the way I see it is again, I mean, we see, I mean, the economy go in cycles. I mean, I mean, it is a very common thing. I've seen it in 2001. We have seen it in 2008. So the cycles are common. I mean, again, U.S. economy is the strongest economy in the entire world. It's a very, very stable economy. So the cycles are always going to happen. And if you look at what the commerce secretary was talking during this whole 100K fee proclamation time, they were talking about an increased unemployment rate in the STEM fields. So the whole thing is they're probably talking something about maybe the economy is not as good as it used to be for the IT fields. We are seeing more unemployment for the STEM graduates, which is why, because there is a very genuine need to protect US workforce. They're talking about implementing this 100K fee, additional fee, because they felt that the STEM graduates, there is more unemployment in the STEM graduates. And again, it's a cycle. I mean, the economy goes in cycles, the industry goes in cycles. So even though in short term it does look like things are looking a little bit bad, long term, I mean, US is still the technology powerhouse in the entire world. There is no country that is close to dominating US in the technology forefront or in the economy forefront. Still the number one economy in the entire world. So to me, I mean, again, if people are looking abroad, the thing is, again, US is still an attractive choice for somebody who's highly qualified, who wants to contribute to the economy, to the industry. To me, US should still be the number one option. And if somebody is on OPT, more than likely they are doing a master's degree in US. They're getting a very, very high quality education in US. So to me, it makes sense that US should still be their first preference. I mean, obviously, yes, because the immigration rules are getting so tough, they should keep their options open. But I think US still has great options. So people should not be discouraged, but again, always give it their best shot.
Absolutely. And to help you in with your case, so that you are on the right path and have all the documents right, it's always best to consult with an immigration attorney. And why not check out Attorney Chand Parvathaneni from SPP Law Firm, Dallas, Texas, and you can visit the link which is displayed on the screen. And well, Chand, we have users who have viewers out there who have been very actively participating. So Ricky, I think we should take up one of your questions, which is relevant to the topic of discussion today, saying, hello, thanks for the session. Will 100K dollars have to be paid for case of concurrent H-1B filing by a second employer after 21st September?
No, we do not have to pay the fee because if it is a concurrent H-1B, so what a concurrent H-1B means is you're already on H-1B status. A second employer is trying to ask for permission so that you can work part time for the second employer while you're still working for the base employer. So the rule is if you're already on H-1B status before September 21st, you're inside the country, you should not have, I mean, the company should not have to pay the 100K fee. So anybody that already had an H-1B before September 21st, but trying to get a new concurrent H-1B petition filed after September 21st, you should not have to pay this 100K fee.
All right. Thank you so much, Chance, for taking that up. And Ricky, I think welcome back once again. You are one of our very frequent viewers. I have already taken up these questions, I remember. But nevertheless, if you have more questions on this topic, keep commenting and we will take up a little later in the show. But now let's take up Sham's comment, which is my H-1B course approved on 27th of September, planning trip of 38 days, 5 to 6 weeks, safe period of staying outside US. Is it a safe period for staying outside the US? We'll be working remotely, so we'll have pay stubs and employer approval. Please advise on safe stay days.
Sure. So I think what it looks like is his H-1B under change of status. So his H-1B got approved. So now he's theoretically in the country on H-1B because change of status got approved. And if you are planning to undertake a trip outside the country, the 100K fee. The 100K fee should not be applicable because my guess is your actual H-1B petition was filed well before September 21st because the case was already approved on 9/27. And if that is the case, I mean, when you go for stamping, you just have to go through scrutiny just like any other H-1B under the prior rules, which means you go get your the biometrics done, and then you attend the in-person interview in the home country. They're going to ask you about your job, your role, your qualifications, and so on. They'll do a background check. If everything checks out, I mean, you should not see any problem. And but the only issue is nowadays because the scrutiny is rigorous. They not only do a scrutiny on the job, the assignment, they also do a lot of background checks on your social media accounts, and everything they can think of. So what that means is, I mean, sometimes you have to be prepared for the delays, and but luckily the good thing is, looks like you're actually taking a longer trip of almost 38 days, which means like the day you take your vacation, go for visa stamping. So hopefully everything is good. But in case you get a 221G, you should be able to resolve it in about 4 to 6 weeks. So hopefully you'll have enough time. So before your vacation ends, you are done with your stamping and you're able to come back. So the bottom line is, again, the rules are still the same. You need to have a bona fide assignment. Your company needs to be a bona fide employer. You need to be highly qualified for this job, and no criminal history. As long as all these things are good, I don't see any problem in the travel.
That's lovely. So have a fun trip, Sham, and let us know when you're back or if you faced any problems, during your travel, so that, even your story could be beneficial for our viewers here watching Immigration Talk Show. And thank you, Chant, for taking that up. So we do have Robert Brave who has also joined us. Samantha, we are going to take up your questions very soon, but now, Chant, I have my a couple more questions, so I'll take some of them. These are also from users, from the real world who are feeling all this chaos and everything confusion. So a lot of users are saying that their employers put all H-1B filings on hold till further notice. So what does that mean in practice? Is the entire season at risk?
No, I think on September 21st, when we saw this guidance from the various agencies where they said a new H-1B file after September 21st is required to pay the 100K fee, a lot of employers, I think, were a little bit confused because they did not really understand if that fee is also applicable to somebody who's in the country doing a transfer or an extension. So I think they're waiting for some data, but now it's almost 20 days since we got the proclamation, and now we have more data. We're seeing approvals, we're seeing USCIS when the filings are done, they're receiving cases and so on. So I think it's a little bit clear. I think the filings on hold was like the initial stage, uh, but again, for the companies that will be liable for the 100K fee, especially for the next cap cases where somebody's out of the country, those cases, I mean, I definitely talk to a lot of companies. They definitely are putting their plans on hold until they get more clarity. Because when I say more clarity, it's clarity from the government, because government is going to give more guidance on how they would interpret things. For example, cap cases, somebody's in the country, somebody's in the country on one status, or somebody's out of the country. So all these variations are there. So I think people are waiting and watching on more interpretation from the government on one hand, and on the other hand, we also have some lawsuits. We already had a lawsuit filed a few days back. So we have so many things going on. Not only that, we're also going to see some rule changes in the H-1B process. We have a H-1B lottery proposal where they want to change the way the lottery is done. It's still a draft proposal out there, and Department of Homeland Security has already started the rulemaking process. And what that means is the final rule probably will come out in the next couple of months, probably by December or January. So when we hear employers putting things on hold, employers don't want uncertainty. They want to run their business. They want to get things done. They want to use highly efficient staff, get things done. And and when employers are seeing some kinds of uncertainty, especially because there is a rulemaking process where rules are getting changed, there is a proclamation, there is a court case, and so on. So it is true, at least for the next cap cases, a lot of employers are putting their plans on hold, and until they get more clarity from the government, from the rulemaking process, uh, and the courts, and so on. At least I think a lot of employers don't want to commit to this process, but at the same time, again, they have to get things done, and what that means is they have to get things done at their companies. So we have to wait and watch and see how things will happen, because if employers do not hire the right people, economy is going to be impacted. But at the same time, we're also hearing news about a lot of fresh graduates coming out, not finding jobs. So that's also a problem, because we have so many of these young graduates who are out there in the market, and if they're not finding a job, that's a problem. So as a whole, I think next couple of months will give us more clarity, and then I think employers are going to be putting a lot of their H-1B cases on hold until they get full clarity.
Right. I think, and it's many folks out there probably are feeling the same way, to wait and watch for a bit, at least let things settle down and then see what happens. So, yeah, there are a lot of questions also from our audience. We will take them up, but since we are talking about this, and we spoke a little bit earlier about the traveling and H-1B approval. So, if an H-1B approved but not yet stamped, could that person still face issues traveling after this proclamation?
No, I mean, I've talked to a couple of folks who recently got stamping done. And again, at the time of stamping, they're going to be scrutinized on the job, the role, their background, and so on. If all of that stuff is good, the 100K proclamation thing should not impact them. Okay, maybe if they run into a problem, it's probably because the consular officer, Department of State, they want to do a background check on the client. Maybe they want to reach out to the client and do some background check on the project assignment, and so on. So those are the kind of things that always happen. They happened last year, they happened the year before that. So it's probably because of that they could see a delay. But as far as the 100K proclamation is concerned, that should not impact people who already have an H-1B approval. So at least if people want to travel, they should not be worried about the 100K fee. But again, they need to make sure the company is legitimate, their background is all good, solid, no social media issues, and so on. Again, if 221Gs are given, usual time I see 221Gs getting resolved is anywhere between 2 weeks to 60 days. Majority of the cases, I do see them getting resolved within 60 days, unless there is something bad in the background, something got flagged or something happened. That is when they could see more than 2 months. But majority of the cases, they can expect an answer within 60 days.
Okay, so the basic rules are still the same. I mean, it still applies the same way, except some changes with which are going on, and that is the fees mostly. All right. But otherwise, still, Chand, I'm sure there are delays because of the government shutdown, and all the most of the officers kind of have to hold on to their duties right now, right?
Yes. Again, luckily, Department of State is not impacted at this point of time. We don't know the impact if the shutdown extends for a longer period of time. USCIS definitely we should not be impacted, because USCIS gets a lot of fees, and the fees is going to fund them. So USCIS should not have any impact. That being said, a lot of other government bodies, they're going to get impacted. So So a long time government shutdown is definitely not good for everybody involved. So hopefully the shutdown is not going to extend for a very long time, but at least as of today, it's almost 10 days. We don't have clarity on whether uh, there is a solution in place quickly or not. And that is something what I think we all have to wait and watch. Last time there was a shutdown, it was almost for more than 30 days. So we have to wait and see what kind of a timeline we are seeing at this point of time. Because the administration, they're also warning about a lot of job cuts going to happen if this shutdown doesn't end very soon. So a lot of federal government employees could be impacted. So in the best interest of everybody, I think I just hope that the shutdown will end very soon. But again, until uh, the Republicans and the Democrats they come to a conclusion very soon, we don't know what is happening, because every day we have our clients, because we're not able to file LCAs, we're not able to file the perm labor applications. So we're getting asked these questions: when is the shutdown ending? Unfortunately, we don't know, and it all depends on the government. It all depends on the Congress. So we just hope for the best. I'm hoping at least, hopefully next week we'll see a resolution.
Yes, let's keep our fingers crossed and hope things get working as soon as possible. And now for my next question, Chand, let's talk a little bit about the cap exemption side also. The cap exempt petitions, universities, research centers, hospitals, are they truly safe? And or do you think they might also lose exemptions soon?
So there are already bills in progress, and there are already proposals in progress where they're talking about should all these cap exempt entities and organizations and universities, should they even have cap exemption? So just to kind of summarize, cap exemption means if that particular entity wants to hire somebody on a H-1B visa, they don't have to go through the lottery. They can simply sidestep the lottery, directly hire somebody without going through the lottery. And this feature, it's available to like universities, public hospitals, and so on. So if a university wants to hire a software developer or a network administrator, they simply can just hire somebody on H-1B. I mean, they don't have to go through the lottery. They don't have to wait until March and register in the lottery. So some folks they feel that it is unfair, especially when there is a lot of unemployment in United States. Fresh graduates are coming out in United States. These universities, which are churning out all these graduates, they should probably hire somebody who's being educated by them, and they should be given a job. So that's there is an argument going out in that format, and it makes logical sense. And for that reason, there are proposals in place where they're talking about uh, should these universities even be given that cap exemption feature or not. So again, there are pros and cons, because a lot of universities hire very talented professors who have PhDs and so on H-1B. And if they have to go through the lottery, they might be missing out on people with a very, very valuable degree, with a good research background, with a good PhD. They cannot hire them if they have to go through the lottery, because lottery is very complex. So exemption makes sense in certain aspects. At the same time, for some cases, I mean, there are good reasons why exemption should not be given. So there are arguments on both sides of the aisle. So there are proposals in place. Again, we don't know what is going to happen, because we know that the administration is working on a lot of key aspects of the H-1B program. At this point of time, I would say it is, I mean, nothing has gone to a point where people have to worry about cap exemption being taken out of hospitals, universities, and research centers, and so on. But again, proposals are definitely out there, and we don't know how the government would change cap exemption for the universities. Maybe they'll modify the current cap exemption. We don't know, but definitely things are in progress to at least revisit and see if cap exemption is good or not for the country.
Yes, absolutely. And that brings me to my next question because there's a lot of buzz also that change of status petitions inside the US might be fee exempt. So is that really a loophole people can rely on?
Change of status is not going to be exempt, because change of status simply means somebody's in the country on some status, maybe a student status or a H4 dependent status. Uh, oh, I think when you're talking about the fee exempt, you're talking about the 100K fee exempt. Sorry, I got it wrong. Change of status inside US, as far as the proclamation is concerned, should be fee exempt, because the current proclamation talks about while you are in the country, you should not be impacted, because the proclamation talks about entering United States. So if somebody is entering United States, they are liable to pay 100K fee. So I think if in the current reading of the proclamation, if somebody is in the country doing a change of status, definitely they are fee exempt. So I don't think it's a loophole. That is how the proclamation was written. So tomorrow, if they want to change the proclamation, they could change it. But in the current format, the way the proclamation is written is clearly stating that if somebody is trying to enter United States, the 100K fee applies. And what that means is it is probably a loophole where if somebody does not go or out of the country, then pretty much they should be exempt from this 100K fee. That being said, tomorrow, if they want to redo the proclamation, they could always include it. But as of today, based on the current reading of the proclamation is the one that controls, not the guidance from the agencies, because the proclamation clearly says it's only people who are entering United States and the president has signed on it. That would be the controlling document. So to me, it is clear that change of status petitions should be cap exempt as of right now. That being said, if they go out of the country, I think they are liable.
Okay. Thank you so much, Chand, for taking that up. And I would also like to welcome Prasunjit, who has joined us right now on YouTube. And I'd like to take up his question. So let's take this. My priority date is current under review. When I have my I-140 approved under EB2, can I apply a downgrade in EB3 premium processing?
So for the downgrade petitions, you can always file a downgrade. Okay, you have an EB2, which means you're obviously qualified for EB3 for sure. And when you do a downgrade petition, so normally what happens is, because you've used the original labor with your first filing, when you do a downgrade, usually you cannot do it in premium upfront. So what we do is we send it in regular process. We wait for about a month for the processing to start, and then we upgrade, because normally sometimes they reject the premium processing if you upgrade it right away. So normally give it about a month and then try to upgrade the case. So initially you would have to file it as a regular processing case if you're doing it as a downgrade, because when you do a downgrade, what you're doing is you're using the same labor application that was used in your initial filing, the same Department of Labor's 9089. Since you're reusing the 9089, they have to make sure they get it from the prior file. So if you're doing a downgrade, do it in regular, wait for a month, upgrade the case to premium.
Wow, thank you so much, Chance, for taking that up for Prasanjit. And I hope you got your answer. Keep commenting if you have more questions, or join us on call, folks out there, whoever's watching. If you have questions that you directly want to ask Attorney Chand Parvathaneni today, this is your opportunity. Call us now on this number 425-436-6335, and the access code is 988888. So, yeah, and also don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram as well. So now let's move on. We have more viewers. Let's take up Selumit, who's saying that I'm worried about using a consulting firm to file my H-1B. How do I know if they are reliable and won't cause issues?
Sure. Again, I think we have two kinds of H-1Bs, especially on the IT sector. One is like a full-time job where you're working with a company like Microsoft, Google, and so on. Then you have other kind, the consulting kind, TCS, Infosys, or maybe a small consulting company, and so on, where you are actually going to work and get outsourced to work at an end client site. So again, I see a lot of concern with people who want to work for a consulting firm. Uh, Again, from a USA standpoint, as long as the job is genuine, the project assignment is genuine, and the company is genuine, in terms of approval, you should not see any difference, because the rules are same for full-time jobs, for consulting jobs. Everybody has to do an LCA, and based on the LCA, based on the location, based on the job duties, the company has to pay somebody. So in terms of approval success rate, to me, as long as the job is genuine, whether it's a consulting company, whether it is a full-time company, uh, the approval rate should not matter. That being said, definitely in the current administration, there is a lot of scrutiny on third-party placements. Okay, when you talk about a consulting company, more than likely it's a third-party placement where the consulting company is putting you to work at a third-party placement site. We are seeing a lot of proposals to uh, uh, to change how things are done for third party placements. Recently, last couple of months back, we had some changes where uh, now you have to disclose whether it's a third party placement, yes or no, on the I-129 form. So this happened last January. And again, going down, I think I can expect a lot of changes on third party placements, on how USCIS processes third party placement kind of H-1Bs. So when you say, like, how do you know if the consulting company is reliable or not? We have definitely seen a lot of companies which probably are shady or fraudulent, because we get noids all the time from USCIS, where sometimes even we are surprised, because USCIS will say, we went to the client side and this is what we saw, or we went to the company and this is what we saw. So again, because there is this possibility of fraud with any company, what you should do is do a lot of Google search. Try to get referrals. Okay, so if you're like accepting an offer with a company, try to talk to some person who directly worked with that company, not hearsay, not somebody saying, I know this company through my friend. Try to see if you can get reliable references where you directly talk to somebody who was employed with that company. You know how that company is. Does that company have a history of benching? Does that company have a history of issues with USCIS or anything of that sort? uh, Typically, Google search, all these are good. And I would always do a lot of research on your side, because there is always this chance that there is something wrong with that company if it's a small company. And USCIS also has the same problem. If the company is small, they do more extensive background checks, because they want to make sure the company has the ability to pay. They're actually going to pay you whatever they are promising to pay you, because H-1B has a lot of compliance requirements. Because the H-1B program, if not done properly, could impact the US workforce. So for that reason, definitely do your own homework, unless you directly talk to somebody who gives you good reference, or you directly done your research to understand that this company is a good company. I would not join that company. And again, if a company has like real major problems and they're debarred from the H-1B program, or ran into some issues in the past, Google and you probably will find out, because sometimes if there is a Department of Justice investigation, you might see it's probably in public record. If you see like some kind of a major issue, you probably will see it as a public record. So always definitely searching public records is one good way to start off. And then the second good way is talk to people who directly work for that company. And yes, definitely, because consulting companies have a lot of scrutiny, I would definitely do a lot of background search, a lot of your own background research before you finalize your employer.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back after the break on Immigration Talk Show. I'm your host, Napasa, and today we are with Attorney Chand Parvathaneni, our guest for today, who is from Dallas, Texas, SPP law firm. And it's been a very intriguing discussion, on today's topic, H-1B cap 2025, and what should you know before filing. Fact, we have such awesome viewership as well. Good to see so many people, folks out there participating with their questions in the comments. Lovely to have you. Thank you so much, Chant, for taking them up. And we do have, follow up questions as well from Sanjeet and a lot from Ricky. Ricky says there's an urgent question also, which I'm going to take up very soon. But yeah, let's take this up for Ricky. How will the new proposed H-1B wage level impact existing H-1B workers? Will employers lay off if they don't want to increase wage level for level 1 employees?
Um, so, so one of the things that was in the proclamation, very important thing was Department of Labor was ordered to go through a rulemaking process to update all the wages. And what that means is the Department of Labor, once this whole process is done and the wages are updated, any new filings, whether it's a transfer, whether it's an extension, existing H-1B workers filing for an extension, the LCAs will have to follow whatever is the current wage at the point of time the LCA is taken and certified. So what that means is if tomorrow DOL decides that the wages have to be bumped up uh, during an extension, the employers will not have a choice, but they would have to increase the wages. So in terms of wage levels, again, USCIS is very, very strict. We are seeing a lot of noise. So the wage levels are not whatever the employer wants to issue. So the wage levels are based on whatever is the job experience requirement for the job, whatever is the skill requirement for the job. Based on that, the employer has to decide the wage level. So if the wage levels are not accurate and if the employer uses a wrong wage level to decrease the salary, we have seen so many notice of intents to revoke and cases getting revoked recently, very recently. Uh, so what that means is the employers have to be very, very cautious about the wage levels they're using. It has to be the right wage level. And down the line, I do expect the wages to increase. Just this July, just a couple of months back, all the wages were updated. So if you look at the wages in June, when we were doing the H-1B filings during the cap lottery, and July and now, because the wages got updated, a lot of wages, especially in the IT sectors, they were updated. And a lot of places, the bump is pretty significant. And I do expect that to happen more and more in the next coming months, because the rulemaking process will let us know what exactly they decide, what is the final rule. And I think the wages will definitely impact the H-1B workers in a way, because in a way it might be good, because the employers will be required to give higher wages because they have to give whatever the LCA requires, and LCA is pretty much whatever the DOL requires. In a way, it could be bad because some of the employers might not be able to pay that high salaries and they might have to lay off some people. So there are again pros and cons, but again, we definitely know that wages are being updated right now. I mean, they're at least they're working on it right now, and I do expect wages to increase, at least for the H-1B requirements, because H-1B wages have to be whatever the LCA requires. So more than likely, I think we will see wages getting increased next year.
Okay. Thank you so much for taking that up for Ricky. And Ricky, thank you for participating for your all your questions. I really hope that you're getting your answers. And now let's take up Robert. Robert, thank you for joining on YouTube. It's asking if OPT expires before the H-1B start date, what are the options to legally stay in the US?
So usually for this kind of situation, what normally happens is there is something called cap gap. So what that means is your company files for a H-1B, and because your H-1B has to be filed a couple of months ahead. Like in this case, H-1Bs could have been filed since April, May, and June. Say the company files for a H-1B for you, and then the start date would be October 1st or later on, and then your OPT expires before that. Usually what happens is there is something called cap gap, where you go to your school DSO and request for a cap gap I-20. So a lot of people, usually you'll be able to go through cap gap, and because of cap gap provisions, you can stay in the country while your H-1B is in process, assuming your H-1B was filed as change of status petition. So I think what you should do is go to your school DSO and check and see if you're eligible for a cap gap in your case.
Thank you for taking that up, Chant, for Robert. Now let's take up Samantha's question. And Samantha's asking, what are the timelines and risks involved if I'm currently on OPT or another visa and planning to file for H-1B?
Sure. So the main thing is if you're on OPT, you're on F1 status, and your H-1B. Again, the next year's H-1B will be filed between April 1st and June 30th because that is when the filing window starts. So the rule is you should be on valid status on the day your H-1B is getting filed. So if your OPT or your F1 status is valid, say in April, and the company files for a H-1B at that point of time, then you're in a pretty good shape because on the day of filing, you have to be in status. And in terms of risks, again, if the H-1B gets denied, you'll be out of status the minute your F1 status ends. So in terms of, again, what I recommend is, I mean, lately I've been recommending people to do premium processing. Do premium processing, at least you'll not have surprises. At least before your status ends, say especially F1, before your status ends, you should have an approval in hand, because by getting an approval, you know that you're in valid status. And uh, if your case gets denied, then you definitely would have to leave the country before your other status expires. In your case, if you have F1 status, you would have to leave the country. So just be cautious about the timelines, and nobody can overstay. And always, everybody should be looking at your I-94s and make sure you don't overstay your visa. And before your visa status expires, you should have a non-frivolous filing done. So in your case, if you're having the H-1B filing done, then you're pretty much good to stay in the country as long as the H-1B is in process. So just be aware of the I-94s, your status, and don't ever be in the country without having proper status.
Thank you so much. And I think that goes out to everyone out there here in the US, who are immigrants, of course. And thank you, Chan, for taking that up. Do not forget to like, share, and subscribe to our channel, all viewers out there, especially that we are taking up your questions. Support us by following us and checking us out on YouTube. Our handle is at Immigration Talk Show. And also, don't forget to check us out on LinkedIn, Facebook, X, and on Instagram. So, Chand, we have our next question. This is from Sumit. Sumit is asking, what are the best practices for documenting the specialty occupation requirement in light of the recent USCIS adjudication trends and RFE patterns?
Sure. The first and the foremost thing that everybody has to do to basically avoid the specialty occupation RFA is give a very, very detailed job description. Don't be generic in the job description. So don't just say, for example, the job duties. Don't just say develop software applications. Be a little bit more detailed. And what that means is, what technologies are you using? What skill set are you using? Uh, I mean, as detailed as possible. So that is the first thing you should target. The next thing you should target is be very, very clear on what degrees, specific degrees, are qualified for doing those job duties. So if you, for example, just to give an example, a software developer, you lay out all your detailed job duties, and the requirement is very unclear. For example, you say, to do this job, we just require a bachelor's degree in engineering or MBA or computer science. USCIS immediately would come back and say, you are saying any engineering degree, MBA, and computer science. These are very, very three widely disparate degrees. They're not very close degrees. And what that means is this job is not specialized, because if you say that this job can be done by people in multiple with an academic background in multiple areas, that is definitely not a specialty occupation job. So what every employer has to do is give you a detailed job duties, and then specify the degree, the real degree that is relevant to the job duties, that has a clear nexus. So for example, if you say computer science, IT, software engineering are related, are required for my job as a software developer, to me I see a clear nexus, because software developer, yes, it is relevant to the job. Computer science, it's relevant. Information technology, yes, it is relevant. Information systems, yes, it is relevant. So just make sure detailed job duties, giving very clearly the degree requirement, and the degree requirement should have a clear nexus. So you cannot just give any random degree and say this degree is required. And by being very clear, I would say that would definitely decrease your chances of specialty occupation if your duties are clear and the degree requirement, the nexus is very clear. So that is one way to stop, at least on the first level. If you unfortunately get like an RFE, then what we also suggest is try to get a client letter where the client talks about the degree requirement in case you are working with a client. If it's a full-time company, what we recommend is go to a professor, a US professor. Try to get an expert opinion on, for example, these are the job duties. In the professor's opinion, what exactly is the degree requirement for doing those kind of duties in the industry? So typically, expert opinions are very valuable. Client letters are very valuable. If at all you get a job, if at all you get an RFE. Another good source is Bureau of Labor Statistics (BLS) or Occupational Outlook Handbook (OOH). So all these places also have documentation on the occupation. For example, if you say software developer, for example, you look at OOH, they clearly say that for doing a job in this particular occupation, a degree requirement in so and so fields is very common. So Occupational Outlook Handbook requirements are also very valuable. And if you include all of that stuff along with your filing, typically you should not have a problem. So to avoid specialty occupation, very clear job duties, very clear degree requirement, and outlook, occupational outlook handbook, which is the government's own um, uh, product. You
Right.
basically take documentation out of that and show what your requirement is. That is the best way to avoid specialty occupations.
Thank you so much, Chand. And it's really lovely to see more viewers joining in. So I'd say thank you so much, Chand, for being such a sport and taking up all of our questions so patiently. We have so much more. So I think we have another 10 minutes to go. And I hope that I can take up almost all of your comments. But
Sure.
even if not, you will
Mhm.
not leave empty handed. So thank you, viewers, really for being participative as well. And Chand, I'm going to take up this next one from YouTube. This viewer, I am Ugandhar. Hi, my H-1B petition has approved on 2024. I'm going to start stamping next week. Going, I'm going to stamping next week. This is my first time travel to US. Will $100K fee have to pay in my case?
No, absolutely not, because this petition got approved before September 21st, 2025. Clearly, you should be exempt from this fee. This fee is for the new applications after September 21st, especially basically from the next cap. So, the next lottery, whoever are going into the next lottery, those people, I think, when they go for their stamping, I think will be liable.
Thank you, Chand, for taking that up, and all the best to Yugandhar. Sham is back again with more questions, so let's take this up. Thank you so much for guidance. Please comment on stays beyond 30 days. Mine is 38 days. There are rumors that H-1B holders should stay for less than 4 weeks outside US. Please advise. This will impact my plan. Please guide.
No, there is no rule of that sort, whether it is 60 days or 30 days. There is no rule of that sort whatsoever. However, I think what's happening is the more longer people stay in outside United States, and especially for, like, say, I've had cases where like 4 or 5 months they were staying abroad and they were able to work. So I think sometimes what happens is, I think I've had some officers question them, hey, you're able to do this job from out of the country, so why do you even need to go into the country? Again, that is like a very, very minority. It is not the norm. But I think the challenges I think people could see is, if somebody is out of the country for a long time, sometimes the CBP officers, they suspect that maybe it is because of benching. The employer had them like go out of the country, and sometimes they feel that when they're coming back, they might not even have a job. So the scrutiny will be more on, hey, you're entering the country. Do you really have an assignment? Does your employer know you're coming? Does your employer have real work for you, not just like speculative work? So the scrutiny is more. And again, when you cross more than 60 days, I typically see a lot more scrutiny. It's not end of the day. I know a lot of cases where in the recent past, in the recent, I would say last 10-15 days, where somebody had like a long stay abroad for other reasons, like medical reason or some other family reasons. Yes, they do have a lot of questions, and if they're able to convince the officer that yes, they do have genuine employment, the company is genuine, they should not have any problem. So per se, I mean, if your travel is for 38 days, there is nothing that says you cannot take a vacation for 38 days, stay out of the country and come back. However, be prepared to show enough documentation to show that the day you enter the country, you have a genuine job assignment, a bona fide assignment. If you have that evidence, 30 days should not be a problem at all.
All right. Thank you so much, Chand, for taking that up for Sham. And Sham, I hope you got your answer. And it's really exciting to see CM who has joined us. And thank you for that, you know, generosity, I would say, 10 US dollars. Wow, that's a good donation. So he's saying, I work full time at a big four firm since OPT, STEM OPT. My H-1B was approved in August 2025. I'm in India now with stamping on October 16th in Hyderabad. Any issues with stamping or return due to new rules?
No, I don't think so. I mean, again, it's a big four. I mean, all these big companies. My guess is he's talking about PricewaterhouseCoopers, all these big Deloitte, these kind of companies. They are very, very big companies. I mean, the thing is, I mean, the stamping. That the main issue for the CBP office. I mean, for the Department of State officer, the consular officer, is to make sure there is a genuine job assignment in US. Employee is all qualified and so on. So when you're working in a very big company, a big four, uh, I mean, you're 100% your job is, it is a genuine job assignment. You have to be highly qualified to get a job in such kind of a company. So I would not worry much about it. I mean, the 100K fee is obviously not applicable to you. uh, I mean, as long as you don't have any criminal history, I don't think you should have any surprises at all. I mean, the only time I would say you should have a surprise is if you have some kind of a criminal history, shoplifting, DUI, these kind of things. If not, I mean, your case should be one of the straightforward cases.
Well, thank you. Thank you so much, Chand. And thank you to CM, for participating and for the generous donation once again. And if you have more questions, keep commenting or join us on call. Viewers out there, this is the best thing about this show that you can join us on call to ask your questions directly to Attorney Chand Parvathaneni. And the number is 425-436-6335. And the access code is 988-888. Also, don't forget to leave a like or subscribe to our channel. Our handle is at Immigration Talk Show. Check us out not just on YouTube, but also on LinkedIn, Facebook, X, on Instagram to stay connected with us, and also ring that bell so that whenever we have discussions like these, you're notified and you can join these very important discussions because there's so much information that's going to be beneficial to you. So thank you once again. And Chand, I'd just like to know how much more time can you spare for us? So because there's so many
I probably have another five
questions.
minutes. Yeah, you can continue for another five
Okay, no
minutes for sure.
worries. No worries. But I think we have taken up most of the important questions from our viewers today, and we should wrap it up. We do have a couple more questions. Maybe you could leave us with a couple more ideas. So, in a best case scenario, if the court strikes down the rule, could employers get that 100K dollar refund?
Uh, I mean, again, I think if the courts strike it down a lot, I mean, and people assuming somebody's already paid that fee, a lot depends on what the final judgment says. So we have to see what the final judgment would say, and uh, is it like a class action, or is it, I mean, who exactly it is impacting and so on. At this point of time, it is too early because I don't even think that anybody is even paying the 100K fee, because theoretically the major impact is going to start for the next lottery season, for the next H-1B cap season. So right now, I think because there are not many people with that kind of a fact pattern where they are liable to pay that 100K fee until the next lottery starts, I think there is a lot of time, and a lot depends on how the court cases are going to be adjudicated. So what we know for a fact is we have one court case so far. More court cases are possible down the line, and not only that, even the government. I think we don't know if they will do some other changes, because instead of a proclamation, if they start doing some changes as a rulemaking process, we don't know. So a lot of things are possible, but at this point of time, I think it is too early to see what would happen if somebody already paid the 100K fee and then the courts strike it down.
Exactly. And with I mean, court cases on, I think we'll just have to wait and watch how the lawsuits turn up. It's definitely a challenging time, but what we can do now is wait for a bit. And Chand,
Yeah.
maybe you could
So
leave
far,
us with yeah,
yeah, so far I've
sure.
only seen one major company come back and say yes, we're going to pay that fee, which is Nvidia. So Nvidia came out and said they're okay to pay that fee, but all the other companies, I think they're still a kind of just processing the information and seeing what exactly is going on and so on. And I think a lot of big companies, I think probably will have enough resources to pay the 100K fee, but a lot of small companies, because in US, I mean, small businesses are also a major factor contributing to the economy. And a lot of companies that do file for H-1Bs, a lot of them are like small businesses. And the small businesses, for them, 100K is a huge impact. And again, not everybody is hiring a software developer. I mean, we also see a lot of people hire a lot of other jobs, and not all jobs pay very high, because if somebody is a software developer in Bay Area, yes, they're getting paid a lot of money because the wages there are very high. But when people are working all over the country, sometimes in a remote area, in different jobs, sometimes as a vet, or various other jobs, the salaries are not, or like as an accountant in a small town, uh, sometimes the salaries are not very high. So I think it is going to be a huge impact on small businesses. A lot of things are up in the air. We'll have to wait and watch and see how things will progress in the future.
Absolutely, we do have to. So, Chand, last but not the least, just if you could leave us with the answer for this, and for workers, who've been laid off and are waiting for extensions, what's the smartest and most practical move that they can make right now to stay compliant and buy time?
If somebody has been laid off, I mean, the big thing is you have 60 days, the 60-day clock starts. So you have to be very, very cognizant of that 60-day deadline, and you cannot even stay in the country one day after that. In case you have, I mean, I've been consulting with people in the last 2 3 days. They have a job offer and they got laid off. Their 60-day clock is ticking, and a few of them have deadlines next week. With the government shutdown, the LCAs are not getting filed. What that means is a H-1B cannot be filed. So there is no way a H-1B can be filed because there is no LCA. So to stay in compliance, at least what we're telling them is, you got to like at least make a filing with USCIS. In this case, I've talked to a person. He has a house. He also has a job offer, and he can't sell the house like in 1 week. The 60-day clock is ticking. There is a government shutdown. So what people should be doing is they should be at least be filing with USCIS, letting them know what is going on. And in this case, for example, a B2 filing. So B2 is a filing that somebody can ask for a maximum of 6 months. You cannot ask for more than 6 months. So if somebody has like a short-term plan and they need to stay in the country after their I-94 expires, definitely let USCIS know by doing this filing. In this case, like a B2 filing, to change your status, and then at least stay back in the country. But without doing a filing, if you're staying back in the country, and if the filing is a again, you cannot do a frivolous filing. It has to be a non-frivolous filing. But if you don't do anything and you stay back in the country, you will get an NTA. I have seen an NTA just last week, actually earlier this week, and I was surprised. I called that person to see if it was a mistake. That person crossed 60 days and he has not done any filing. He just stayed back. So we told him to make sure he goes in front of the immigration judge, because now he cannot just leave the country. So once you get an NTA, it's not that you just go out of the country directly. You have to appear in front of an immigration judge. So it complicates things. So compliance is very important. A 60-day grace period is very important for somebody who's requiring to file an extension. I-94 end date is very important. You cannot stay in the country even for one single day after your I-94 expires, unless you have a proper extension filed. So the bottom line is everybody should be looking at their I-94, or if somebody is laid off, their 60-day grace period. Take a decision accordingly to ensure you don't have even a single day of overstay.
Very important things to keep in mind, Chan. Thank you so much for touching them up. And I think it's a wrap, but what is happening is from surprise approvals to skyrocketing fees. I think there's confusion everywhere. So this H-1B cap 2025 is anything but normal. So maybe just three things to keep in mind, so that people know what they should know before filing.
Um, so main thing for the H-1B cap, I think the main things they need to know is somebody in the country doing a change of status or consular processing is very important. I'm like strongly advising people not to. I mean, like somebody's in the country, I'm strongly advising people to do it as change of status, not as consular processing anymore. Because in the last couple of years, I've seen people who are on F1 file for consular processing, and at the time their F1 expires, like they're in such a challenging situation, they have to go out of the country for stamping or have to file another change of status petition. So rule number one, I mean, always make sure whether if you are in the country, change of status or consular, To me, I suggest change of status. Number one. Number two, the degree requirement. So any employer trying to file for a H-1B, make sure your employee is qualified. And what that means is, if they don't have a relevant degree, they could run into a problem, because work experience evaluations are not always accepted by USCIS. Sometimes they will point out issues, they will poke holes in your experience letters. So somebody that is hiring H-1B workers, always make sure they're highly qualified. And for H-1B, it is always academic qualification. Yes, you can use work experience uh, as a backup. You can use work experience evaluations, but if they have a right degree, the right academic qualification, the right specialty occupation, specific degree, that would make uh, the adjudication is a lot more easier. So always look at your degree requirement. The third one is, keep monitoring the news, the DOL news about wage increases, because wage levels, because next year we don't even know how the lottery is going to be conducted. They're clearly saying if you do a wage level 1 filing, you might not even have any chance in the lottery. We don't know yet, but we will know only once the final rule comes out. So everybody should be looking out for the final rule. USA has already started the rulemaking process for lottery changes. So the third one is the wage levels. So the companies who are filing for H-1Bs, you have to be looking at how the wage levels will impact the H-1B lottery for the next year, for the cap.
Well, thank you. Thank you so much, Chand. Those are great tips, and I'm sure that this session is going to be very beneficial to all viewers out there. I mean, each and every one of you, thank you so much for joining us. This show wouldn't have been the same without you participating on this as well. And Chand, thank you so much, really, once again, for your time and for taking up each of our questions so patiently and giving us such great tips and answers. It was such a great session, and I hope to see you soon again.
Yeah, thank you so much, Nipasa. Bye bye.
Bye bye. Have a great day. Thank you, viewers. You all also have a wonderful day ahead. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And keep commenting if you have any more questions. Also, after the stream has ended, we will try to bring answers to you. And nevertheless, don't forget to subscribe and hit that bell icon so that whenever we have these discussions, you can join us. And also, don't forget to check out Attorney Chand Parvathaneni in case you want to also get in touch with him, have a one-on-one discussion, or get a consultation with him. Check him out. He is none other than Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. You can also visit the link which you can see on the screen. And once again, thank you. If you also want to get in touch with me or you have some questions, you can write into me over via WhatsApp or call me in this number 408-335-6444, or just email me at info@staffingly.com. But once again, thank you, everyone. Keep in touch with us on YouTube, LinkedIn, Facebook, X, and on Instagram. Bye for now.